Hello. We're going to give it just a minute here to let everybody join in, but we'll start directly at the bottom of the hour here. All right, well, I show 12:30 Eastern, so good afternoon to the Eastern side or good morning to the Central folks. We're going to go ahead and get started because I know we have a lot of information that's going to be jam-packed into this 30 minutes for you. But hello and welcome to today's webinar, which is hosted by Old National Bank and Old National Wealth Management and sponsored by Women Lead. My name is Stephanie Ewing, and I'm a corporate banker here in our Indianapolis market, and I'm also the national co-chair for Women Lead. I'm excited to kick off our first of what we hope to be a series of webinars focused on women and wealth. I know we have employees, clients, and friends of the bank who have joined us today. For those of you who are not familiar, Women Lead is one of Old National's internal impact networks. Our mission is to cultivate an inclusive environment where all women thrive and their unique contributions are valued and recognized. One of our goals is to empower women with information, so we're thrilled to have you with us all here today. With that, I'd like to introduce you to Chris Brumfield, who is a wealth advisor for 1834, a division of Old National Bank, and will serve as today's moderator, and Jean Kriegbaum, Chief Wealth Planning Officer for Old National Wealth Management, who will be today's main presenter. Chris, I'll turn it over to you.
Thanks, Stephanie, and thanks to everybody who is joining us today as we talk all things estate planning 101. So why did we choose this topic and why the focus on women? Let's start with the focus of why we're focusing on women. According to a 2020 McKinsey study, by the year 2030, American women are expected to control much of the $30 trillion in financial assets that baby boomers will possess. This results in a potential wealth transfer of such a magnitude that it approaches the annual GDP of the United States. With this in mind, we also know that female life expectancy outpaces the male counterpart by an average of 5 years per the Social Security Administration. In addition, women tend to be the caretakers of the family. They tend to be concerned with things such as guardians for minor children and plans for aging parents, which can be impacted by the estate plan. With that as a framework, let's discuss our goals for our webinar today. By the conclusion of our time together, we hope to provide a better understanding of the following. What is an estate plan and why do you need one? How do assets pass or transfer? What is probate and do you need to avoid it? Which documents do I need? What do fiduciaries do and how do I choose them? So with those being the objectives that we cover in our time together today, let's just jump in with, did you know? Did you know that 33% of Americans have an estate plan? Considering this also means that 67% of Americans don't have one. That's 2 out of every 3rd person. And the reasons for this really include a wide variety of reasons why. And 40%, for instance, they've procrastinated. They just haven't gotten around to it. 33%, they believe that they don't have enough assets to pass to their loved ones. 13% believe that estate planning, the process, is just too costly. 12% don't know how or where to start. So even if you think you don't have an estate plan, you really do. Where there isn't an estate plan, state statutes in each respective state will dictate what happens to your assets. So with that, Jean, let's dive in and talk all things estate planning. If you can start by walking us through exactly what is an estate plan.
Sure, I'd be happy to. And thanks everyone for joining us today. I think it's helpful, especially when it comes to something that might seem daunting or overwhelming, certainly not terribly fun, to break things into more bite-sized pieces. So when it comes to your estate plan, I like to think of it as the how and the who. How would you like your assets to be handled when you're gone? and who would you like to handle them? In other words, who do you want to be responsible for carrying out your wishes? So at a high level, that's what an estate plan is. It's a set of documents that outlines the how and the who.
That's a great description. Really like that as far as to really encapsulate that. Now, today, I realize we are not talking about financial planning, but we have been receiving many questions lately from clients asking us the difference between an estate plan and a financial plan. For those of you who may have wondered the same thing, we're going to pop a resource into the chat that explains the difference between the two. All right, next question, Jean. Now that you've explained what an estate plan is, can you discuss why we need one?
Sure. So everyone should have an estate plan in one form or another. You mentioned it already, Chris. Whether you have one or whether you think you do or you don't, you do. And what I mean by that is that every state has a statute that outlines how your assets are going to pass if you pass away without a plan. So I looked up a couple of states in particular that are in our ONB footprint. So for example, if someone passes away and they leave a surviving spouse and children, if they live in Indiana or Illinois, the surviving spouse is going to receive half of the estate and their children will receive the other half. In Minnesota, the surviving spouse receives everything. In Michigan, the surviving spouse receives a fixed amount of $150,000 plus half of the remaining estate. So with that said, very rarely is the plan that's laid out in the state statute what you'd really like to see happen. So some of the most common reasons that people choose to formalize their estate plan are what you see here on your screen. It allows you to name a guardian if you have minor children. There's a potential to reduce or even eliminate estate taxes, avoid probate, and we're going to talk a little bit more about that. Protect your assets and your beneficiaries, and overall, just make things easier for your family. So I think with all of that said, that the biggest mistake you can make when it comes to estate planning is just simply failing to plan. So that's why we're here today, and that's what we're hoping to talk with you about.
Jean, those are very compelling reasons to address an estate plan. So related to this, can you talk a little more in depth about all the different ways that assets are passed once a person passes away?
Yeah, so the way your assets are titled now will dictate how they're going to pass when you're gone. And that's why I think it's most important to start with this when we think about estate planning. This is what we talk with all of our clients about. If you're on the phone and you've talked with me about this, likely we've already discussed it. So most assets you'll find fit into one of four buckets, and that's what you're looking at right now. So from left to right, those assets that pass by contract. Some of the examples include, you see on the bottom, life insurance, retirement accounts are very common examples. What happens is you've named a beneficiary, you should have named a beneficiary, and assuming that you have, those assets are going to pass to the beneficiary upon your death. By law is very similar. The most common example that you see there is joint tenant with right of survivorship. Of course, we see that most often with the primary residence. But other examples are transfer on death and payable on death, which apply, of course, to bank accounts and investment accounts. So assuming that you've named a joint owner or a payee, that asset is going to pass to the surviving owner or the beneficiary upon death. The third column is pretty self-explanatory via trust. If you own a trust and that trust owns assets, those assets are going to pass to the beneficiaries in the terms that you've identified in that document. You'll also see, before I get to the final column, those are under that kind of black banner at the top of non-probate property. What that means is assets that fall into one of those three buckets are not subject to the probate process. Everything else, if it doesn't fit in one of those, goes through probate. That's that fourth bucket over there. And you'll see examples, assets that don't fit into the other categories, right? So assets that pass through the probate process are going to pass to your heirs. So with that said, a lot of planning can be accomplished simply by way of your asset titling and beneficiary designations. So putting together a comprehensive balance sheet is a very, very important first step.
Terrific. Thank you. I just want to pause here and take a little bit more time to talk about the probate process. It's a term that's often thrown around, and many people view it as a negative, and they believe that they should try to avoid it. Can you spend some time talking a bit more about what the probate process is and frame up the pros and cons?
Sure. Yeah. So probate is summed up as the definition you see here, a legal process where certain assets that were owned in your individual name are distributed by the court. And that's whether you have a will or not. So I do think while we often hear the word probate described as a terrible thing, sometimes that's because there's a general lack of understanding about it. You know, people don't like it, but they maybe don't really know why. The probate system itself was designed to protect your accounts and your property and the financial security of your family whenever possible. So in the interest of being more objective, we've outlined some pros and some cons. The pros on the left side, it's a defined process. Every state has a process. The attorneys that you'd work with know exactly what that process is and how it works. It's repeatable. The second is it enforces your intentions. If you've got a will, it's going to work those assets through the process identified in your will. And the third positive or pro is that it can reduce or eliminate your estate planning costs. And what I mean by that is if you have a will and your assets are going to pass through a probate, that tends to be a less expensive plan to set up. On the alternative side, on the cons, time. The probate process takes time. Every state has a defined period of time that a probate needs to be open. So for example, in Minnesota, the probate has to be open a minimum of 4 months to allow creditors to make claims against an estate. Every state has a timeline like that. I know that it's been a while since I checked, but on average, we used to say that the average probate takes about a year. So time is a con. Expense. It costs money. Typically, there's an attorney involved. There are court fees, sometimes filing fees that have to be paid. Another kind of caveat to the expense is if you own real estate in more than one state and that real estate's owned in your individual name without a joint owner and no beneficiary, your properties will be subject to probate in more than one state. Every state that you own real estate in. So that can really increase that expense figure. And then a public proceeding. So for a lot of the clients that we work with, that tends to be maybe the biggest con or the biggest negative is filings in a probate are public. So the one that I use as an example is an inventory. When a probate is filed, an inventory is filed, and that's just like it sounds. It's an inventory of the assets that are subject to this probate. So people are nosy, you know, and anybody can go down and take a look at that public filing. So the privacy piece of that tends to be a big con on the probate side.
Terrific. Jean, thank you for that. I appreciate you spending extra time on that to really showcase what probate process is. Let's now turn to estate planning documents. There can be a lot of them, but can you walk the group through what the core documents are?
Sure. So we've got what you're about to see here. We have 4 different documents that we consider part of your core estate plan. Starting in the top left, your financial power of attorney. That is the document that you use to designate somebody to act on your behalf for all things financial, should you be unable to do that. Moving down, the healthcare directive. This is the one most people are familiar with because likely if you've been to the doctor as an adult, they've asked you if you have one. This is the document that outlines what you want your care plan to be in the event you're not able to make those decisions on your own. Moving to the top right, a will. So the will is, as many of you may be familiar to, the document that can distribute the property that you own upon your death, subject to probate. And a revocable trust does the same thing, only is set up during your lifetime with the idea that you might have assets in there ideally during your lifetime, where will really doesn't kick in until death. So wills and revocable trusts tend to operate very similarly in that they both outline how would you like your assets to be distributed upon your death and to whom. But there are a couple of distinctions. And the key that I think I would like to point out is, for example, a will is the only document that allows you to name a guardian for your minor children. So that's key. With that in mind, on the right-hand side, you'll see there's really 2 different configurations for these documents. On the top, you see what we call a simple will plan. That means that the will is the primary governing document when it comes to asset transfer. Along with that, you'd have a financial power of attorney and a healthcare directive. In the alternative, you might say, I like the idea of a revocable trust as well. And so then you're going to have a will and a revocable trust plus the financial power of attorney and a healthcare directive. And I just want to highlight, you'll notice that instead of calling it just a will in this instance, we call it a pour over will. And what that means, it's sort of literal. What it means that to the extent there are assets that you have not put into your revocable trust, they're going to pass via that will through probate, but all it's going to say from a public kind of proceeding standpoint is if I forgot to put something in there, they're going to go into the revocable trust. So the detail that's filed with the court is much, much less.
Terrific. It is so helpful to see this laid out so clearly. But before we move on, can you just spend a little time talking about wills versus revocable trust a little bit further? Can they essentially accomplish the same thing?
Yeah, so they're very similar, but we have highlighted some of the differences. And also on here, you'll see some of where they're the same. So starting at the top, probate process. We've talked about that a little already. Assets passing via will are subject to probate. I do think that's probably one of the biggest misconceptions that I saw when I was in practice, and I still see in wealth management is people will say, I've got a will, I don't need a probate. And the opposite is true. If you only have a will and there are assets that are owned in your name individually, you will have a probate. And the alternative, if you have a revocable trust and it's funded, those assets are not subject to probate. And I want to highlight this because I also think one of the biggest mistakes that we see is a client will come to us and say, I've got this revocable trust. Isn't it great? Yes, but you've put nothing into it. And what that means is we've taken, if you think back to that probate versus non-probate asset transfer page, we've taken what should be non-probate assets that are going to pass by trust, and now we've made them probate assets. They'll still wind up in the revocable trust. It's just going to take an extra step. So I like to add that caveat there. The guardian, I've already mentioned, a will is the document where you name a guardian. They're not named in a revocable trust. It's why if you have minor children, you will always have a will. Incapacity. A will does not appoint, because it doesn't really become effective until death, it doesn't appoint a guardian in the event of incapacity. The court has to do that. Where in the alternative, a revocable trust will usually have some instructions in there that say, hey, if this happens and these people agree, then I'm going to be considered incapacitated and we're going to move on to the next trustee, the next person to be in charge here. Privacy, we've talked about, so I won't keep beating that point, but the probate process is a public one. Generally with a revocable trust, only the beneficiaries are informed. So again, when I think of some of the biggest differentiators, that is one of them. Legal fees tends to lean a little bit more in favor of the will side of things, meaning it's less expensive to establish. Again, because there are no assets that need to be transferred, you draft the document and that's it. And the alternative to make the revocable trust really as effective and efficient as it should be, like I've mentioned a couple of times already, there are assets that you want to title into that trust, and there are sometimes fees that go along with that. And the final point is flexibility. In this category, they're identical. Both of these documents can be revised, edited, whatever you'd like, as many times as you'd like during your lifetime. So there's no difference in terms of flexibility. Those are some differences, Chris.
Jean, thank you. That is great information to really think about and to consider in each individual's position. But one more question related to estate planning documents before we move on. You've done a great job of outlining what the core documents are, but I'm guessing that there are those on the line today listening and wondering which documents are best for them. Can you provide a little guidance around that?
Yeah, so it's a question that we get all the time, and it really is a personal one. I wish that I could say, if you check all these boxes, then this is the set of documents you need, but it doesn't quite work like that. So here are some things to consider. What types of assets do you have and how do you own them? For example, if all of your assets have a named beneficiary, maybe you can handle a simpler will plan. Maybe the revocable trust isn't necessary. Do you own real estate in more than one state? We've talked about that from a probate process and the potential for not only one probate, but multiple. What age and stage are your beneficiaries, and are they financially responsible? And how would you like your assets to pass when you're gone? That's a tough question, one that is it requires some thought. But simply, do you want assets to pass outright? Are there assets that you want to be held for a longer period of time and maybe distributed at points in time over the course of your beneficiaries' lives? Another point that's not on here, but I think is also critical, is your total net worth. Sometimes the higher the net worth, the more important it may be to have that revocable trust plan for things like the privacy aspect and the ease of administration during your lifetime and following upon death. So those are just a handful, but certainly everybody's plan is going to be unique to them.
Great. One last question before we wrap up today. The term fiduciary, it gets used a lot, and especially where it comes into estate planning. Can you walk us through not only what a fiduciary is, but who they are?
Yeah, so I imagine many or maybe even most of you on the call have heard the word fiduciary before, but we do get the question when it comes to an estate plan about what is it, what does it mean, and why do I care, right? So the definition on the page is fiduciary is a person or organization with a legal and or ethical responsibility to act on behalf of someone else and to put the interests of that individual or group ahead of their own. I normally don't like to just read what's on the screen, but I think that's really important, in particular, the part about putting the interests of the beneficiaries ahead of their own. That's who we're talking about when we talk about individuals or groups, are really your beneficiaries. Who these people might be, these fiduciaries, they may be individuals. Oftentimes that might be somebody like a family member, a spouse, adult children. It might be friends or other key advisors. Some attorneys will act in this capacity. You maybe have a CPA. You maybe just have somebody that you really trust that's an individual. Institutions, places like Old National Bank. Banking institutions are often able to act as a fiduciary for some of these roles. And then there are professional fiduciary firms. That's all they do, or it's a big part of what they do is to act in that capacity. And there are pros and cons to both. And just like with the type of plan that you have, whether an individual or individuals make the most sense for you and your plan versus incorporating a professional fiduciary is really going to depend on the type of assets that you have and what it is that you'd like to do with them, as well as the beneficiaries that we're talking about. And that's where we can really get into dynamics and things like that. So with that said, I would like to spend a few minutes talking more specifically about the fiduciaries that relate to the documents that we talked about today. So first, the financial power of attorney. So this is, again, the person that will make decisions about your non-trust assets in the event that you become incapacitated. The name of that fiduciary is called an agent. That form may take a different name depending on the state that you're in, but it serves the same purpose. So the next question that we get then is, how do I pick who makes for a good agent, a financial power of attorney agent? And that is the key, really, somebody that's financially responsible. They don't need to be a CPA. Not all of us are blessed to have a CPA in our family. I know I'm not, but it needs to be somebody that's organized, and if they've got some financial experience, great. The next is the healthcare directive, and the person that you'd name there is also called an agent. This is the one, when I look at the 4 different documents that we have here, oftentimes I'll see clients where they've named the same person for every document except this one. This is different, and it's different because it's the person that makes the healthcare decisions for you when you're not able to do that. And sometimes that person is maybe not the same one that's really good with finances or really good with time management, but they have this other really great skill, right? And you know that they're going to be able to carry out your wishes. So oftentimes we see if clients have a family member that's in medicine, maybe they're a nurse or a doctor, or they're just comfortable with it. But this is one in particular, you really need to make sure that the person that you choose knows that they've been chosen. You should do that for all of these, but really for this one, make sure they know that they've been chosen and they know what it is that you'd like them to do, and make sure that they're able to do that. So that's the healthcare agent. The will, you're going to need to name at least 1, maybe 2 of these positions. The executor, also known as a personal representative, that's the person who's responsible for settling your estate. So I think of this as sometimes more of a short-term position. Like I said, if it goes through probate, which is when we would use this document, that tends to be on average about a year. The other role that you may need to name if you have minor children is a guardian. Again, this may not be the same person as the executor, right? But this is the person or people who are responsible for taking care of your minor children in the event you are no longer here. That tends to be a tough one. I've had a lot of folks that really get stuck on, I know who to name for everything, but that one's tough. But it's also, I think, the most important. And finally, the trustee of the revocable trust. So with a revocable trust, if you decide to move forward with that plan, or maybe you already have one, you are usually the initial trustee because assets in that type of trust are still considered yours for tax purposes. There's no new tax filing or anything like that. I know we didn't have time to get into all of that today, but from a legal standpoint, they're still yours to do with what you want. So you would be the initial trustee. So then we'd be looking for somebody to handle things more long-term. If you have a spouse, they are often the first person that you would choose for a lot or maybe all of these roles. However, the challenge is if you work with an attorney to get some of these things done, they're going to ask you for a successor. And sometimes that's harder to come up with. It's often that first choice for all of these is easy, but we challenge you to come up with at least one successor in the event that initial person is no longer here to do it. So I want to wrap up here, Chris, before I turn it over to you with kind of 2 points. When it comes to the fiduciaries, like I said, always have a primary and always have an alternate. And when we're thinking about the documents and the people, so the who and the how, or the what and the who, I really think it's helpful to think about this in terms of 5 years. It can be very overwhelming. We can what if these things to death. If we say, well, gosh, I don't know, like, what if this child grows up and they get married and they have children, or they don't, or, what if I get married, or what if I do? You can what if these things to death, and then what happens is you just don't do it. You just don't put a plan in place. So I really challenge the clients that I talk to think about the next 5 years. If something happened in the next 5 years, what type of documents would you like in place, and who would you like to receive your assets? That tends to make it a bit more manageable. So that's what I've got. Thanks, Chris.
Thank you, Jean. We really appreciate all this terrific information. Now, as we bring this topic to a close, we want to offer some next steps and action items based on what we discussed today. First of all, if you have an existing estate plan, when is the last time you looked it over? Was it when you initially received the document? Did it go into that important drawer or on that important shelf not to be viewed again? Here's the opportunity to take a look and identify anything that's outdated. We've outlined on this slide 6 life events that recommends your estate plan be updated. Or if you don't have an estate plan, reach out to an estate planning attorney to get the process started. We've also identified information to gather in anticipation of that first meeting with the attorney. Now, if you don't know of an estate planning attorney to contact, just reach out to your Old National Bank wealth advisor who can provide you with a few estate attorney names within your respective market. And also discuss with your wealth advisor any additional details or questions that you have around this process. And finally, establish your own personal deadline to address and complete this most important process to give you and your family peace of mind. With that, I'll turn it back to Stephanie to close us out.
Well, thank you all very much for joining us in our inaugural webinar focused on women and wealth. And thank you so much to Chris and Jean for all the insightful and actionable information provided here today. If you would like to go back and revisit something that was discussed, a replay of the webinar will be emailed to you shortly. If you are interested in additional information and insights related to women and wealth, we invite you to visit oldnational.com/resources/insights and type in the word women in the contact search bar. A list of articles of various topics will appear for you to read, and we'll be on the lookout for an invite for future webinars as well. As always, the team at Old National would be happy to answer any of your questions directly, so don't hesitate to reach out to the person who invited you today. Thank you all very much and have a great day.